In this lecture, we would start another aspect relating to law, and in that regard, we would like to discuss about law of carriages. And as law of carriages are divided, carriages of goods by land, carriages of goods by rail, or carriages of goods by sea, or carriages of goods by air. So, in regards to carriages by land, two acts govern the very carriages of goods by land, as one is the Common Carriers Act 1865 and the Railways Act of 1989, and in case of carriages of goods by rail, the Railways Act 1989, and by carriages by sea. And when it is pertaining to carriages of goods by sea, the acts govern are the Indian Bills of Landing Act 1856, the Carriage of Goods by Sea Act 1925, the Merchant Shipping Act 1958, the Marine Insurance Act 1963, and in case of carriage of goods by air, the Carriage of Goods by Air Act 1972 governs the carriage of goods by air. And when you will discuss the first one, that is carriage of goods by land, in respect to that, we could say that it is a contract of bailment. So, generally, carriers are classified as common carriers, private carriers, and gratuitous carriers. And as per the Act of Common Carriers Act 1865, which defines what exactly a common carrier means, a common carrier can be an individual or a firm or a company, but exclusively the government of a state or the central government are not considered as common carrier as per the definition of common carrier. And every common carrier is engaged in the business of transports of goods, and that also for money, and that transport of goods from place to place, either over land or inland waterways. And all carriers of goods, they carries good for the consignors. And as regarding that, all the common carriers carry goods for the consignor for hire and not from free of charge. And every common carrier must be engaged in the business of carrying goods for money from one place to another. So whenever any person carries goods either free of charge or occasionally is not a common carrier. So the very common carrier, either a person or a firm or a company must engage in the business of transports of goods for money from one place to another, overland or in inland waters, and the very requirement that the freight chargeable by the common carrier must be paid to him, and there must be accommodation on the very convenience of the common carrier. And another condition that is falling under the definition of Common Carriers Act 1865 that there is nothing objectionable or illegal about carrying of goods of a particular consignor. And even the carrier, as per the definition of the common carrier, reserves the right to himself either to accept or reject the offer of an consignor. So, these are the criteria laid down under the Common Carriers Act 1865. And as regarding private carrier, a private carrier does not transfer goods from one place to another regularly. It does it occasionally, and it is a kind of casual job for the private carrier for certain selected person. In fact, it carries the own goods of its and not engaged in the business of transport of goods from one place to another for an consignor regularly for money. So, it is known as a private carrier and not a common carrier, as because it does not engage in the business of transport. Neither one can hire a private carrier for transport of goods from one place to another for money. And also, in that case, a private carrier is only carries someone's goods under certain terms agreed upon between the private carrier and the person. So, besides that, there is another carrier, and that is called the gratuitous carrier. So, whenever a person carries goods of another free of charge, he is a gratuitous carrier. Similarly, a person may give lift in his transport to another person voluntarily without any compensation. Thus, a gratuitous carrier may carry not only goods but persons also free of charges. So, the very act, the Common Carriers Act 1865, provides certain rights and duties of the common carrier. So, as such, the very rights of a common carrier Under the Common Carriers Act 1865, a common carrier is entitled to settle remuneration in cash. No remuneration was settled to a reasonable remuneration. And also he has a right to refuse to carry goods under certain circumstances, and which are enumerated when we will discuss under the very duties of a common carrier. And another right of the common carrier is that he has a lien on the goods of the consignor for his remuneration. So he can refuse to deliver those goods of the consignor until his charges are paid. Besides that, a common carrier has the right, if the consignee refuses to take delivery of the goods when tendered by the common carrier, so the common carrier has a right to deal with the goods as he thinks reasonable and prudent under these circumstances. So also a common carrier has a right to recover reasonable expenses incurred by him as a result of the consignee's refusal to take delivery. After giving notice to the consignee, the common carrier may even sell those goods which are perishable in nature. And another right of the common carrier is that he can recover damages from the consignor if the goods are dangerous or are loosely packed and the carrier suffers injury therefore. And the last right that a common carrier under the Act is that he can limit his liability subject to the provisions of the Common Carriers Act 1865. And now we'll discuss the very duties of the common carrier. A common carrier is bound to carry goods of all persons who choose to employ him. He can, however, refuse to carry goods under the following circumstances. And those are, if there is no accommodation in the carriage, so in that circumstance, a common carrier can refuse to carry on the goods. Or if the person employing him is not willing to pay reasonable charges for the carriage of goods, or if the goods are such which is not accustomed to carry, or if the goods are to be carried over a route which is not his regular route, or if the goods are dangerous and as such subjecting him to extraordinary risk, or if the consignor refuses to disclose the nature of the goods to be carried, and finally, if the goods are not properly packed. And as such, the second important duty of a common carrier, he must carry the goods over the usual and customary route and take all reasonable precautions for their safe carriage. He must not deviate from the usual route unless rendered necessary by exceptional circumstances. Also, he must deliver the goods at the agreed time And if no time had been fixed with a reasonable time, and also a common carrier at common law is an insurer of the goods in the sense that he warrants to carry the goods safety and securely. And besides that, we would like to discuss certain liabilities that were laid down under the Common Carriers Act 1865, and that also regarding the scheduled goods and the non-scheduled goods. So we have to discuss the very liabilities of a common carrier in regards to scheduled goods and non-scheduled goods. So the question arises, which goods are falling under scheduled goods? So the scheduled goods are those which are enumerated in the schedule of the Act, and such scheduled goods are valuable articles like gold, silver, precious stones and pearls, bills, and hundies, currency notes and bank notes, glass, silk, articles of ivory, timepieces, musical and scientific instruments, all these are falls under scheduled goods, and these are valuable goods. Besides that, all other goods are non-scheduled, and for scheduled goods, the Act prescribes that all articles of scheduled goods exceeding Rs 100 in value, the carrier is liable for loss and damage only. And if the value and description of the goods are disclosed by the consignor to the carrier, or if the loss or damage is due to criminal act of the carrier or his agent or his servant, so in that case the common carrier would be held liable. So the common carrier can charge extra for carrying scheduled articles, and these scheduled articles are valuable as already we have discussed above as defined under the Common Carrier Act 1865. And as regards to non-scheduled articles, a common carrier can limit its liability by special agreement with the consignor. But even in this case, you will be liable under Section 8 of the Common Carriers Act 1865. So exactly what Section 85 of the Common Carrier Act provides regarding the carrier's liability, that we would like to discuss here. As Section 8 provides that a common carrier is liable for loss or damage caused by negligence or criminal acts done by himself, is either by himself or by his agents or by his servants, and the very burden of proof regarding such negligence and criminal acts was no criminal act on the part of the carrier or his agents or servants. Is always lies upon the carrier, and it was decided in an important leading case, and that important leading case was decided by the Honorable High Court of Patna in the leading case, Banwari Lal versus the Road Transport Corporation in 1984 by the Patna High Court while determining the liability of the common carrier as per the provisions of Section 8 of the Carriers Act, and as such also the very strict liability concept is applied to common carrier. As it was mentioned earlier, that liability of a common carrier is more that the liability is in accordance with the English common law. And whenever the very question of strict liability of a common carrier is applied as per section 8 of the Common Carriers Act 1865, the very liability, however, does not arise in certain cases. And those principles of strict liability would not applicable under such certain situation and circumstances where such loss or damage caused to the goods of the consignor due to an act of God or by enemies of the state or by the inherent vice in the goods carried or by defective packing or by the fault or fraud of the consignor. And as under common law, so also under the Common Carriers Act 1865, the very exception to strict liability principle of common carriers regarding the exception as in relation to an act of God as it is defined, there are accidents which are caused not by human agency but by the elementary forces of nature, such as the natural calamities, storm, earthquake, heavy rains, etc., or tsunami or cyclone. No human agency can predict or foresee the occurrence of these events reasonably, and therefore their consequences cannot be prevented by human intervention or by reasonable precautions. Therefore, if the occurrence of a particular event concerning natural calamities, so which could not be avoided, then it would not amount to fall under the strict liability of the common carrier, as it could not be avoided in any circumstance, as it is falling under an act of God. And as regarding the second exception to the principle of strict liability, applicable to common carrier is regarding enemies of the state. So, in that case, no liability of a common carrier would arise if the damage or loss of the goods of the consignor in the common carrier is caused by the declared enemies of the state. So here the very phrase enemies of the state means all the alien enemies at war with India. However, goods damaged or lost due to general strikes, rebellions, or internal riots are not covered by this exception, as these are caused by human agencies. And the third exception available to a common carrier is that inherent vice in the goods carried. No liability of a common carrier would arise if there is an inherent vice in the goods carried. For example, there may be natural loss by evaporation of the liquids carried by him. This loss is beyond his control and therefore he could not guard against it. In case the goods requires special care and precaution in handling them, the consignor must communicate those to the common carrier. For example, if goods are fragile or are to be carried in particular position, there shall be no liability of the common carrier if he has not been informed about the special conditions regarding those goods to be transported by the common carrier from one place to another. And another exception available to the common carrier is regarding defective packing. So now no liability arises of the common carrier in case the loss is due to the defective packing of the goods by the consignor. This is so even if he was aware of the defective packing, even if when he received the goods, the very responsibility was laid down under the act on the consignor, not on the common carrier, regarding defective packing. And lastly, the last exception found regarding the strict liability of the common carrier is regarding the very fault or fraud committed by the consignor. So no liability of the carrier for loss or damage to goods arises due to a fraudulent conduct of the consignor or acts or omissions of the consignor or his agent. So under this exception, if the very act of the consignor and in regarding transporting goods under a common carrier, if it is fraudulent in nature, or the very act is considered as fraudulent, and if there is any acts or omission of the consignor or of his agent and servant is committed regarding the very goods to be transported through the common carrier, Then also the common carrier could not be held strictly liable under the very Act, the Common Carriers Act 1865. So, in this lecture, we have discussed in regards to law of carriage by land and in particular about the Common Carriers Act 1865 and exclusively relating to transport of goods by land or by inland waterways by a common carrier. And in that connection, we have already discussed and the very definition of a common carrier and how does a common carrier differ from a private carrier. And also we have discussed regarding a gratuitous carrier and those very rights and duties as laid down under the Common Carriers Act 1865. So also the carrier's liability and also the application of the principle of strict liability in case of the common carrier and what exceptions are provided to a common carrier as such that we have discussed. If any loss and damage caused to those goods transported by the common carrier of the consignor, if the loss and damage caused due to an act of God or by enemies of the state or by inherent vice in the goods which are carried by the common carrier, so also if there was defective packing of those goods carried by the common carrier, and also lastly the exception available against strict liability of the common carrier is regarding the very fault and fraud of the consignor or of his agents and servants. So all these exceptions are available to the common carrier in case of holding the strict liability principle in case of a common carrier's fault or in regards to the loss and damage caused to those goods transported by the common carrier of the consignor under the very Act, Common Carriers Act 1865.